In the United States, 73% of parents who have a will name their oldest child as executor. 73%. And in a significant portion of those families, that single decision made out of tradition, out of habit, out of a guilt they cannot even name, is the decision that turns a grieving family into a divided one. Not because the oldest child is wicked, not because they are lazy or dishonest, but because being executor of an estate is a specific, complex, legally demanding job that has almost nothing to do with who is the most responsible, the most trusted, or the most loved. And when the wrong person is handed that job, even a wonderful person, even a devoted child, the weight of it breaks relationships that took a lifetime to build. My name is Webb, and today I am going to show you exactly what an executor actually does, why seniority in the family has nothing to do with who should do it, and the 5 ways that naming the wrong executor quietly destroys the families that parents spent their whole lives trying to protect. The story of Harold and his 3 children. Harold Benner was a retired machinist from Dayton, Ohio. He was 79 when he died, and he left behind a paid-off house, a traditional IRA worth $240,000, a small brokerage account, a savings account, and 3 adult children in roughly equal standing in his heart. Robert, the oldest, was 54, a retired high school principal, organized, steady, the sibling everyone turned to in a crisis. Denise, 51, was a nurse in Cleveland. And Gary, 47, was a self-employed electrician who had struggled financially for most of his adult life and had borrowed money from Harold twice that had never been repaid. Harold had done what 73% of parents do. He had named Robert executor. Robert was the oldest. Robert was the responsible one. It seemed so obvious that Harold had not spent more than 5 minutes on the decision. Harold had no idea what he was asking Robert to do. Within 3 days of Harold's death, Robert learned that being executor meant he was personally responsible for filing the probate petition in the county court. He had to inventory every asset Harold owned. He had to notify all of Harold's creditors and give them time to file claims. He had to continue paying Harold's bills, utilities, insurance, property taxes out of the estate account while probate was open, and he had to open a separate estate bank account to do it. He had to get the house appraised. He had to file Harold's final income tax return. He had to manage the IRA distribution, coordinate with the financial institutions, and navigate the tax implications for 3 adult beneficiaries under the Secure Act rules that had changed 2 years earlier. Robert was a retired principal. He had never done any of this before. He hired an estate attorney, which was the right call, and which cost the estate $6,000. He made one decision about the house. He listed it 2 months into probate at a price the attorney suggested was slightly high for current market conditions. And when the house sat unsold for 4 months and had to be price reduced, Gary accused Robert of mismanaging the sale on purpose to delay his inheritance. He did not say this quietly. He said it in a group text that included their mother's sister and 3 cousins. Denise, to her credit, defended Robert publicly. But privately, she had her own frustration. Robert had not consulted either of them before listing the house, because the attorney had told him he had the legal authority to make the decision, and he had assumed that was the same as having the right to make it alone. It was not the same thing, and everyone in the family felt it. The estate took 14 months to settle. By the end, Robert was exhausted, Gary was not speaking to him, and Denise had put enough emotional distance between herself and both of her brothers that family Christmas, which had happened every year for 50 years, did not happen that year. Harold had left his children $240,000 and a house, and what they actually inherited was a year of conflict, a strained sibling relationship, and a wound that would take years to heal if it healed at all. What an executor actually does. Let me be specific about what Robert was handed, because most people who name an executor have never thought through what they are actually asking that person to do. An executor, called a personal representative in some states, is the legal agent responsible for administering your estate after your death. The job involves 7 major categories of responsibility. First, the executor must locate and file your original will with the probate court, petition to be formally appointed by a judge, and post a bond in many states. This is the beginning of a legal process, not a simple paperwork task. Second, the executor must inventory every asset you own. Every bank account, every investment account, every piece of real estate, every vehicle, every item of significant personal property. In many states, this inventory must be filed with the court. Missing assets create personal liability for the executor. Third, the executor must notify all known creditors and publish a legal notice in a newspaper. Yes, a newspaper giving unknown creditors a window to come forward. They must evaluate every creditor claim, pay the valid ones in the legally required order of priority, and dispute the invalid ones. Fourth, the executor must manage the estate's assets during the entire probate period, which averages 9 to 24 months. This means maintaining the property, paying bills, managing investments, keeping records of every single transaction, and filing accountings with the court. Fifth, the executor must file the decedent's final income tax return, the estate's income tax return, if the estate generates income during administration, and in larger estates, the federal and state estate tax returns. These are not the same document, they are not filed at the same time, and the deadlines have consequences. Sixth, the executor must distribute the assets to the beneficiaries in accordance with the will, document the distributions, and obtain signed receipts. And seventh, the executor must formally close the estate with the court and be discharged from their fiduciary duty. This is not a favor. This is a job. And is a job that comes with serious legal exposure. An executor who makes a mistake can be held personally liable to the beneficiaries for any loss their error caused. Why the oldest child? Is the wrong default. When parents name their oldest child executor, they are almost never thinking about any of that. They are thinking about something else entirely. They are thinking about who is the most trustworthy, the most level-headed, the most reliable in a crisis. And those are all real and valuable qualities. But they are not the qualities that determine whether someone will be a good executor. The qualities that matter for an executor are financial literacy, specifically, the ability to understand estate tax returns, investment accounts, and creditor priority rules. Organizational discipline, the ability to manage a multi-year, multi-document legal process without losing track of deadlines. Emotional distance, the ability to make impartial decisions about assets while simultaneously grieving, while siblings are watching and judging every move. Legal comfort, the ability to work with attorneys, courts, and financial institutions without being overwhelmed. And availability, the actual time to do this job, which in a complex estate can absorb hundreds of hours over 1 to 2 years. Being the oldest does not confer any of these. Being the most responsible in day-to-day family life does not confer any of these. And the mismatch between what parents assume the executor role requires and what it actually requires is the source of almost every executor conflict I have ever seen. The 5 ways the wrong executor destroys families. The first way is resentment from siblings. When you name one child as executor and not the others, you are giving one child legal authority over assets that belong to all of them equally. Every decision that executor makes, how fast to sell the house, which attorney to hire, how to handle a disputed debt, is a decision their siblings did not get to participate in. If those siblings already have any tension with each other, the executor role will amplify it. If they do not, it may create it. The second way is communication failure. Most non-professional executors do not know they are legally and ethically obligated to keep beneficiaries informed throughout the process. They make decisions, assume their siblings understand, and then discover too late that their siblings felt excluded, suspicious, or disrespected. The most common complaint in estate disputes is not fraud. It is, nobody told me what was happening. The third way is competence gaps that cost money. An executor who does not know estate tax rules may miss a filing deadline. An executor who does not understand how to time asset distributions may trigger unnecessary income tax. An executor who prices a property wrong, too high or too low, costs the beneficiaries money. And when that money is lost, the siblings who lost it are looking directly at the person their parent trusted and wondering why. The fourth way is time and energy collapse. Being executor while grieving a parent is an enormous emotional and logistical burden. It frequently leads to the executor neglecting their own life, their job, their health, their own family for months. And when that sacrifice is not recognized, or when it is actively second-guessed by siblings who have no idea how much work is involved, the executor ends up resentful of the very family members they were trying to serve. The fifth way is the impossible position on debt and conflict. If your estate has outstanding debts, a contested item of personal property, or a beneficiary who is owed money by the estate, or who owes money to the estate, your executor is the person who has to collect it, contest it, or deny it. When that executor is your child, and the person on the other side of that dispute is their sibling, you have put your child in an impossible position. No matter what they do, they lose. The professional executor option, there is a solution to all of this, and it is not complicated. Name a professional executor, a bank's trust department, a licensed professional fiduciary, or an estate attorney as the executor of your estate instead of or alongside your oldest child. A professional executor has no emotional stake in the outcome. They have done this job hundreds of times. They know the deadlines, the forms, the creditor priority rules, and the tax filing requirements. They charge a fee, typically 1 to 3% of the estate's gross value, but that fee is almost always less than the cost of the family conflict, the legal errors, and the extended timeline that an inexperienced executor produces. More importantly, a professional executor removes your children from the impossible position of having authority over each other. Your children are beneficiaries. They receive, they do not manage. The professional handles the complexity, and your children are free to grieve their parent rather than litigate their inheritance. If you do not want to name a professional as sole executor, consider naming a co-executor, one of your children, alongside a professional or a trusted attorney, with clear delineation of who makes which decisions. This gives your child involvement without giving them sole exposure. What if you want to keep it in the family? If you have decided that a family member must be the executor, here is how to choose correctly. Do not choose by birth order. Choose by skill set. Ask yourself, which of your children has the most experience managing finances, working with legal or government institutions, and making decisions under pressure without taking things personally? Ask which of your children has the most available time, not who is the most successful, but who has the most flexibility in their schedule over the next 1 to 2 years. Ask which of your children has the most neutral relationships with their siblings. The executor, who is also the sibling with the most family conflict, is a problem waiting to happen. Sometimes the middle child, the quiet one, the one who was never assumed to be the obvious choice, is the right choice. And whoever you choose, tell them before you finalize your documents. Ask them, do they want this job? Do they understand what it involves? An executor who is blindsided by the role at the worst moment of their life is an executor who is set up to fail. 5 mistakes parents make with executor selection. Mistake number 1, choosing by birth order instead of skill set. Age is not a qualification. Choose the child who has the right combination of financial literacy, availability, and emotional neutrality. Mistake number 2, not telling the executor in advance. Your executor should know they have been named, understand the role, and have access to your documents and the location of your original will before you die. Discovery at the funeral is too late. Mistake number 3, naming co-executors without defining decision-making authority. Co-executors who cannot agree must petition the court to resolve disputes. If you want co-executors, your documents must specify which decisions require joint approval and which one executor can make independently. Mistake number 4, naming an executor who lives in a different state. Most states require an out-of-state executor to post a higher bond, hire a local attorney, and sometimes appear in person at court hearings. This adds cost, time, and complication. If your executor lives far away, factor that in. Mistake number 5, never revisiting the choice. The child you named executor at 45 may have a serious illness at 62. The person you named as backup may have moved to another country. Executor designations should be reviewed every 5 years and after any major life change in the family, your 30-day action plan. In week 1, pull your current will and find the executor designation. Read the name. Now ask yourself, does this person have the financial literacy, the time, the availability, and the emotional neutrality to do this job? If the answer is not a clear yes on all 4, mark it for change. In week 2, have a conversation with the person you are considering, whether that is a family member or a professional fiduciary, before you finalize anything. Walk them through what the job actually involves. Ask if they are willing. A named executor who does not want the job is a serious problem. In week 3, call your estate planning attorney and discuss whether a professional executor, a co-executor arrangement, or a trust with a corporate trustee makes sense for your estate's complexity and your family's dynamics. In week 4, update your documents, store a copy of your will where your executor can find it, and write a short letter to your executor explaining where everything is: account numbers, attorneys, insurance policies, digital assets, and the location of the original will. That letter costs nothing and can save your executor months of searching at the worst possible time. The greatest gift you can leave your family is not the size of your estate. It is a plan clear enough and a process smooth enough that your children can grieve you without fighting each other. If this episode helped you see something in your plan that needs to change, subscribe and share it with someone who needs to hear it today. I am Marcus Webb, and your family's financial future is worth one honest conversation.